The Lord Byers.
My Lords, I beg leave to ask the question standing in my name on the order paper.
My Lords, I assume the noble lord is referring to the Shoeburyness range and the associated facilities. Her Majesty's government would be very pleased to arrange through the usual channels for members of this House and indeed of the other place to visit the range. There are, in fact, no coastal artillery installations at Shoeburyness.
While thanking the noble lord for that answer, may I ask him if it would be possible for this visit to take place before the order for the Stansted Airport is tabled in the House, so that members of both Houses could satisfy themselves on the validity of the estimate of £25 million which is required to remove this range if an alternative site is to be provided there for an airport.
I congratulate the noble lord on keeping his supplementary in order. I will arrange, if he wishes, that this visit takes place at the earliest possible opportunity, and while giving no undertaking, I think it is very likely it will take place before any order is laid.
Is the Lord aware that I am delighted with that answer?
Lord Elton.
My Lords, I beg to ask the first question standing in my name on the order paper.
My Lords, the views of the Consumer Council have been taken into account, with those expressed by other organisations who have been consulted about the regulations which Her Majesty's Government proposed to make to control the noise from motor vehicles. The maximum permissible noise levels which these regulations propose are regarded as a first step and are in line with agreement reached under the Economic Commission for Europe as the lowest practicable levels which can be achieved at the present time. It remains the stated objective of Her Majesty's Government to advocate the adoption under the Commission of progressively lower maximum permissible noise levels as research and development indicate what can be done.
My Lords, I thank the noble lord for what I'm sure, when I've been able to digest it, will prove to be a less disappointing answer than I'd expected. But may I ask the government please to bear in mind that it was a wise man who said that hell is probably a very noisy place?
Well, I thank the noble lord for what he said about the first part of the question. The second part, well, I'm not sure if he was wise or if he was a foolish man, and I'm not sure that I can agree with what he said anyway.
Could the noble lord give any indication when the government to present these regulations? This matter has been going on for a considerable period of time. Quite a lot of research has been done in connection with it. I'm sure London Transport itself, with their buses, have done a wonderful job of work in connection with reducing these noise. And could my noble friend say whether in these proposed regulations there will be anything done at all with a view to stopping motorcyclists taking out their baffle plates out of their silencers and so getting a considerable reduction in noise in that particular direction?
Well, I can't say when I shall be able to give my noble friend the information for which he's asked. All I can say is this: I can repeat what I said to the noble lord who tabled the question, that this is a first step. The situation will be watched, and at the appropriate time, it's hoped that this noise level will be further reduced.
Could I ask, noble lord, in view of the fact that the certain cars for export from this country already are exported with making far less noise than some of the cars we have in this country that are used here, would it not be possible to take some steps to see that the level of noise that is exported is the same, or our noise here is anyway no louder than that which is allowed for export?
It's certainly an interesting point the noble Baroness has raised, and I'll see that what she said is brought to the notice of the appropriate ministry.
The noble lord, for this information, are there not permitting a good deal more noise than the Wilson Committee recommended?
This may be so slightly, my lords, but I can remind the noble lord that this is just the first step, and the situation will be watched, and we hope it will be possible at the appropriate time to reduce the noise.
Lord Elson.
I'd beg to ask the second question standing in my name on the order paper.
My Lords, my right honourable friend, the Chancellor of the Exchequer, is considering this problem.
My Lords, while thanking the noble lord for that lengthy answer, may I first ask whether he can confirm the approximate figures quoted in my question and specify, if so, specify as to what period of time they cover. And secondly, may I ask whether the government considers it possible for Indian and Pakistani immigrants to obtain in their own country supporting documents which can be submitted and accepted as with confidence as reliable evidence by our inland revenue authorities. And if that is possible, why have not all immigrants long ago been warned that unless they can produce such documents, their claims will not be allowed? And if it is not possible, must we not expect much larger losses to the revenue than we ought to tolerate?
My Lords, the estimated losses of the order of £5 to £7 million a year, and this has been going on for about 4 years. As for the possibility of checking the validity of these claims, it is possible to call for supporting evidence. The difficulty is ensuring that it's genuine.
But Lords, isn't it quite clear by now that this is an impossible task for the Inland Revenue, who are already overworked? And as the Chancellor of the Exchequer is considering this matter, would he consider whether the time has not now arrived when dependents of immigrants do not qualify for tax relief unless the dependents are in this country?
I quite agree with the noble lord that the Inland Revenue authorities have got a very difficult task on their hands if they're going to check all these alleged dependents for whom tax relief is claimed. The other point which the noble lord mentioned is one, of course, which will have to be taken into consideration.
Lord Crook.
I beg to ask the question standing in my name on the order paper.
My Lords, as it was announced on Monday, the Secretary of State for Economic Affairs and the Minister of Technology have referred the question of these price increases to the National Board for Prices and Incomes for examination.
My Lords, while thanking the noble lord for the announcement which was made after the question was put down, may I now ask him whether the second announcement can be expected from the government that they will pin the present prices where they are until the inquiry is over?
My Lords, the question of the use of the powers to not to prevent but to cause to revert prices which have risen pending an examination by the NPIB is a difficult one. The relevant ministers do not consider it appropriate to use the powers in this case. They regard these powers as something which should be kept for extremely flagrant cases. They doubt whether this is one because the price of the batteries in question has not risen for 8 years past, because there is no patent on that type of battery, so anybody could copy it and make it at a lower price if they wanted, and above all, because this type of battery is not used in National Health Service hearing aids.
Would my noble friend not agree that it's desirable to have the same policy both for wages and prices?
As a general proposition, my Lord, the government naturally has the greatest possible sympathy with what has just been said, but in particular cases one must take account of particular factors.
Well, would the noble lord tell me, if he can, why it is that had there been an increase of wages for the deaf, the government would probably have had no difficulty in withholding every single thing back?
Because I'm not at all sure that that would be true after 8 years.
My Lords, Mersey Tunnel, Liverpool-Wallasey Bill. I beg to move that this bill be now read a second time.
The question is that this bill be now read a second time. As many as are of that opinion will say content. The contrary not content. The content so.
My Lord, Scottish Life Assurance Company Bill, I beg to move that this bill be now read a second time.
The question is that this bill be now read a second time. As many as are of that opinion will say content. The contrary not content. The content so.
My Lord's Mid Glamorgan Water Bill, I beg to move that this bill be now read a second time.
The question is that this bill be now read a second time. As many as are of that opinion will say content. The contrary not content. The content so.
Ploughing Grants Emergency Payment Scheme 1968, the Lord Beswick.
My Lords, I beg to move that the Ploughing Grants Emergency Payment Scheme 1968, a draft of which was laid before this House on the 22nd of January 1968, be approved. Under this scheme, my Lords, farmers who have had their livestock destroyed because of the foot and mouth epidemic will be able to obtain grants of £10 an acre towards the cost of ploughing up their grassland. Noble Lords will be aware of the various ways in which the National Agricultural Advisory Service and the NFU are planning to assist farmers in the steady replacement of their lost livestock. As I indicated in our debate on Monday, this special ploughing grant will help to ease the pressure for replacement animals and so help to maintain stability of prices by assisting farmers to provide an alternative source of income from a cash crop such as wheat or barley. Farmers may decide to switch to cereals only temporarily, but even so, it will provide a breathing space during which they can rebuild their flocks or herds in a planned and orderly fashion. Particular care has been taken to make the conditions of this scheme as simple as possible. Though at the same time, we need, of course, to ensure that the grant is available only to those to whom it is intended should benefit from it. My Lords, I do not think you will wish me this afternoon to detail the terms of this scheme, apart from explaining the conditions of eligibility. The majority of farmers affected by this epidemic will have had their animals slaughtered because of an outbreak on their own or on an adjacent farm, and these will, of course, be eligible for grant aid. But others whose animals are slaughtered whilst on agistment or on grazed common land will also be eligible. In the latter case, however, farmers with more than one holding are limited to grant aid for ploughing up only one of their holdings, which must be one from which the animals came before they were grazed out. I think noble lords will agree that it would be unreasonable for a farmer who has livestock destroyed on, say, the Welsh hills to obtain grant for ploughing up more than one of his other farms in a part of the country far removed from an infected area. Perhaps I can touch just briefly on the other main conditions of the scheme. The land ploughed must be agricultural land, suitable for ploughing and cropping, and must have been down to grass since before 25th of October 1967, which of course is the date of the first outbreak of the epidemic. And also, it must have been must be at grass at the time of ploughing. Grant is payable on completion of ploughing and on one of the subsequent operations listed in the schedule to the scheme, as under the earlier ploughing grant scheme. My Lords, I am sure that from what was said during our debate on Monday, that there will be a general welcome to this special form of aid for farmers who have suffered as a result of a most disastrous epidemic. I beg to move.
The question is that this motion be agreed to.
My Lords, may I thank the noble Lord Beswick for describing this scheme to us, and I suggest that it is a scheme that we should certainly welcome for the value that it gives, but I would like to make a point about the very limited help which it will give to this hard-pressed section of the farming community. The estimate of the acreage which is likely to qualify is something of the order of about 250,000 acres. That's assuming a average 100-acre farm for the 2,300, 2,400 farms which have been affected. And I noticed that in a debate in another place, the Parliamentary Secretary gave the Ministry of Agriculture's estimate of the number of acres which are likely to qualify and be applied for this grant as being something of the order of 25 to 30,000 acres. In other words, my Lord, something like a tenth of the total acreage concerned. And the value of the grant given would therefore be, if that acreage is in fact applied for, about £250,000. That would add about 1% to the total value of the compensation given. And whilst I recognise the point that the noble Lord Besic made, that this grant has a secondary value in so far as farmers take it up, they will thereby postpone the purchase of their replacement stock. That will to some extent have a benefit for all in easing the demand on the market. I would nevertheless make the point, my lords, that this assistance to the 2,300 stricken farmers is really no more than marginal. I'm looking the gift horse in the mouth, not the noble lord, whose mouth I know is more than generous, but I do want to make the point, which I hope that his right honourable friend, the Minister of Agriculture, will take note of, that at any rate some of these dairy farmers, principally, who have not got private insurance policies to cover them against consequential damage, and therefore only have the compensation money, they will be out of production for at least 6 months, and probably partially out of production for another 12 to 18 months after that. They are going to be desperately short of money over the next year or two. And I really do believe that they will need more help than this to get them through and back into production again. And the point I would like to put to the noble lord is that whilst welcoming this as a valuable and sensible measure as far as it goes, I would ask him to put it to his right honourable friend that something more is almost certain to be needed, and will he please watch the position very closely and see what further specific help can be given to these very hard-pressed farmers.
My Lords, I too welcome this without any very great enthusiasm. I welcome it more really because I think it's a token of the fact that the government are aware that rehabilitation is a very important matter in this respect, rather than that I think that this measure will do very much good. It isn't really always very easy to change your policy of cropping at the last moment, and after all 6 months, as far as farmers are concerned, is the last moment. Very often, if you're a small man, you haven't got the equipment, and you may well live in an area in which there are not very many agricultural contractors. Nevertheless, I think that it will give some small measure of help, but it is a very small one, and I echo very much what the noble Lord Nugent has said, that I do hope the government will see ways to do something more. One last word. It has been suggested that this might encourage farmers who have been in milk to go into arable farming instead, which is not what we want. I understand from various people and bodies that I've consulted that this is not really very likely and that there is no danger in this connection. Well, my lords, I welcome it, as I say, with in a rather lukewarm way.
I too welcome this order that's now before us. I certainly think it's something that we might very well do and, of course, are doing. I would only just say one thing about the speech of the noble Lord Nugent. I do hope that farmers will have the good sense from now on to insure against possible loss, the sort of loss that he mentioned. It was a very bad policy having regard to the fact that we have had these outbreaks from time to time. If farmers hadn't taken upon themselves the responsibility of insuring against the loss, which inevitably they suffer when their animals are slaughtered. The only other point that I would ask a question that I'd ask my noble friend, I'm a little bit out of touch, is this special grant in addition to the ploughing grants already in existence for ploughing up old grass?
Might I just support what has just been said about farmers insuring against the loss? It used to be a very small premium. I don't know what it is now. Something like, I think we were paying 7 6%. It may be more now. But surely it ought to be made a condition that farmers ought to insure against consequential loss, which they will be able to do at a perfectly modest premium, and that ought to be made a condition of our getting this ploughing ground. And I hope that the noble Lord will be able to include that in the regulations, or at any rate make it a condition, give an undertaking that he will make it a condition when action is taken under these regulations.
My Lords, may I just say thank you for the general welcome that has been given to this scheme. It is only a small scheme, as the noble Lord Nugent said, but it is a generous token in its way, and although the amount involved, some £250,000 possibly, is small in relation to the total amount of compensation which is directly paid, which is of the order of £30 million, nevertheless, to those who do avail themselves of the offer, it can be very useful indeed. I'd just like to make the point that the £250,000 or the 25,000 acres is, of course, our estimate of the farmers who will wish to avail themselves of the scheme. More would qualify, and it will be a matter, of course, for them to apply, and if they come within the terms of the scheme and if their land is suitable for ploughing, then, of course, it would mean that the amount of compensation would be increased to that extent. The noble Lord mentioned the other losses which not only farmers but other service industries have suffered during this wretched period. We did debate this very thoroughly on Monday, and I don't wish to go into it again. I simply emphasize the fact that no government so far has accepted any liability for consequential loss, and I think it would be impossible so to do. I would echo, if I may, although I'm very loath to appear to be preaching to farmers, but I would echo the very wise words of my noble friend Lord Champion, who pointed out the benefit of insurance, and I hope it will be possible for others from this time on to take out an insurance against consequential loss. The noble Lord made some point about credit facilities. He said that they will be in, or was it the noble Lord Airedale, who spoke about the need that there will be for money in the period before they begin to get their wage checks again. I would say that the banks and the various credit organizations are being very helpful in this regard, and so far we have had no particular complaint about that. The noble Lord said that the noble Lord Champion asked me about this being in addition to the other ploughing grant scheme. If they had previously benefited, they can again, if they so qualify under the terms of this scheme, they can draw their £10, but not under the 1967 scheme. My Lords, I hope with that we shall be able to agree to this order.
Before the noble Lord sits down, may I ask him whether or no this grant will be subject to tax?
The grant itself is not, of course, revenue. The whole procedure will enter into the financial returns of the farmer.
Would the noble Lord just make it clear about the 1967 scheme? I have thought that only the Part 2 scheme now applied, which means the land must have been down to grass for a period of over 12 years, and there must be conditions of special difficulty. Is this not the case?
What I tried to say to my noble friend was that if any farmer had benefited under the Part 2 scheme, but in the past, but now at the time of this foot and mouth disease had returned to grass and was grazing a herd which was slaughtered, he can claim again, but they cannot claim under the 1967 scheme.
Lord, if he could just make this point about taxation clear, because I'm sure this is a sentence to which publicity will be given in the farming press, and to which many farmers will obviously want to be entirely clear. And I don't think that the reply he gave was entirely clear. And I'm sure it'll be easier in the end if it's cleared up now.
Yes, I'm not sure that if the noble lord wishes me to go into technical language, I can satisfy him. But what I said, it would not be accounted as revenue. This £10 per acre will not of itself be liable to taxation, but the proceeds of the workings of the land which has been so improved will, of course, be.
The question is that this motion be agreed to. As many as are of that opinion will say content. The contrary, not content. The contents have it.
Second reading of the Street Offences Bill. The Lord Chorley.
My Lords, I beg to move that the bill be now read a second time. My Lords, on May the 27th of 1965 at Preston in Lancashire, a man was observed by the police driving his car slowly about the streets and approaching various women to whom he spoke. The police had no doubt that his objective was to take one of these women away with him for purposes of sexual intercourse. And indeed, most of the women, if not all of them, were known to be prostitutes. They accordingly charged the men with soliciting for an immoral purpose under Section 32 of the Sexual Offences Act, 1956, which makes it an offence for a man to solicit for immoral purposes. Before the justices, the point was taken that this section does not cover such a case as this was, and the justices, who were satisfied that a prima facie case had been made out against the man, decided to state a case for the opinion of the High Court as to whether this point taken in the defence was correct or not. In the result, the High Court, by a majority, held that the section was concerned with procuring and similar activities and was not aimed at soliciting for ordinary sexual intercourse. The charge was accordingly dismissed. Some people have read this case as meaning that charge could not be brought in respect of what is commonly known as curb crawling. But of course its implications are very much wider than that, and in effect come to this, that a man can't be dealt with under this section of the Sexual Offences Act for soliciting a woman for sexual or immoral purposes. This case of Crook and Edmondson, which was decided just 2 years ago in 1966, received a good deal of publicity at the time, and indeed was received with a great deal of indignation in many quarters, an indignation which I must say I felt myself, because it underlines a fact which had been argued about a good deal during the passing of the Street Offences Act in 1959, that men and women were not placed on a par with each other in regard to this type of offence. There are really two causes why there was a great deal of indignation about this and why this indignation still persists. The first, and I think the more important of the two, is that it, as I say, underlines this fact that in this part of our criminal law there is in fact discrimination between men and women. And my main object in bringing this bill before your Lordship's House today is to abolish this inequality. My Lords, this is a particularly apposite time, if I may say so, for us to take action of this kind. You may have seen that in a recent little book which has been brought out to celebrate this year, which is Human Rights Year, that
quite a point is made of the fact that there is still a great deal of inequality in respect between men and women in respect of prostitution. Let us, my lords, in 1958 take this further, secure this further human right. It is, of course, a right of women to secure their claim for equality with men in this sort of matter. And this year, as your lordships will remember, is in fact the 50th anniversary of the year in which the women were first given political, or some degree of political equality, when they won the vote. So that for both these reasons, it would be very appropriate for us to give this bill a second reading today. My lords, there is also this practical point. It is, as I've said, just 2 years ago since this case of Crook and Edmondson was decided, and in the interval really nothing has been done, nothing whatever has been done to deal with this injustice in the law which was revealed by that case. The late Home Secretary did, I think, at one stage, in answer to a question in another place, say that he was thinking of or proposing to refer this matter to the Law Revision Committee when they had time to deal with it. Perhaps my noble friend Lord Stonham will be able to say how far that has been taken. The other source of indignation, of course, is this, that at the time when the Street Offences Bill was going through Parliament, the fact that it was aimed at women, and at a particular class of women only, namely the common prostitute, was brought up in both Houses of Parliament. Indeed, amendments were moved to substitute the words any person for the words common prostitute for the purpose of securing equality in this matter. And it was then pointed out that a good deal of offensive conduct of the same character as was aimed at by this bill took place on the part of men, and that it was only fair and right that the bill should cover this sort of activity, whether by men or by women. But in reply to that, the Home Secretary, in another place, and this view was supported in your Lordship's House by the then Lord Chancellor, stated that this Section 32 of the Sexual Offences Act, which was discussed in Crook and Edmondson, gave to the police all the powers that they needed to deal with this sort of conduct on the part of men. Now, of course, the decision in Crook and Edmondson showed that this ministerial view, which had been pressed with such confidence on both Houses of Parliament, was quite wrong, and that Parliament ought not to have allowed itself to be put off, so to speak, from doing what was right and making the law clear at the time when that bill was going through. And I think that this unfortunate episode has a lesson for us. It shows that it's really not safe to withdraw amendments in this sort of situation because you're told by the Minister that the existing law already provides for the situation. We've all heard that statement made more than once, and I think we couldn't have a better illustration of the danger of trusting to it than this case of Crook and Edmondson gives. But, my lords, even if Crook and Edmondson had gone the other way and upheld the use of Section 32 in circumstances of this kind, I would still maintain that it's an unsatisfactory measure for dealing with this type of case. It originated, of course, in the Vagrancy Act of 1898, which was framed, at any rate in respect of this particular section, for the purpose of catching out the prostitute's bully. And it was concerned, that is to say, with the activity of procuring and other similar sorts of activities, as indeed the High Court held in the Crook and Edmondson case. It wasn't aimed, of course, at ordinary sexual intercourse. And it was very much because of this, of course, and because the Sexual Offences Act was a consolidating act, merely collecting together earlier statutory enactments on this sort of matter, that the High Court reached its decision in the Crook and Edmondson case. The sort of offence at which Section 32 is directed is a much more serious one than the sort of offence with which the Street Offences Act is concerned. It's an indictable offence, and it can be punished with up to 2 years of imprisonment. And even when it's tried summarily, as it can be, it carries a 6 months imprisonment, whereas the third offence under the Street Offences Act may carry with as much as 3 months. So that there's obviously a very considerable difference, and it's really quite unfair to men in a way, even if this section had been effective for this purpose, that they should be dealt with under a quite different type of act, and an act intended to secure a very different purpose. It's been suggested that there are so few cases in which men are involved in soliciting that there's not much need to have further legislation. I think, my lords, that this is quite wrong. Curb trawling, which is very much in point in connection with this bill, is good proof to the contrary of this. And my lords, already at the time of the Wolfenden Committee, this business of curb trawling had become a real nuisance, which the committee recognized, although they didn't feel that they were called upon to make any special recommendation about it. But it is dealt with in paragraph 267 of their report, and I would like to draw your lordship's attention to it, because there are some points, I think, which are very apposite there. They say our attention has been drawn to what we are informed is an increasingly prevalent form of solicitation by men of women, commonly described as curb trawling. The form that this takes is that a motorist driving slowly and overtaking women pedestrians halts by them with the intention of inviting them into his car. This is undoubtedly a serious nuisance to many well-behaved women, and it does not appear that from the point of view of prosecuting those who are responsible for it, it fits conveniently into any existing category of offence, except at the point where a specific invitation is addressed to an individual, which really means that they themselves didn't think, their legal advisors must have advised them to that effect, that Section 32 was appropriate. And later on they say that there are difficulties in dealing with this legislatively because of difficulties of proof and other difficulties, and therefore on the whole they decided not to make any recommendation about it. Since that time, undoubtedly, this has become a much more serious evil. Especially, I think, my lords, in the larger cities. Its growth was commented on, indeed, by Mr. Justice Sachs in his judgment in the Crook and Edmondson case itself. And the Josephine Butler Society, which has been very much concerned with all this business and is very much concerned today and has taken a large part in the campaign for bringing this bill before your lordship's house today, has got a great deal of evidence that this is indeed a very real nuisance in many large towns up and down the country. I could take up quite a lot of your lordship's time by quoting from material which has come to me over the last week since this bill was published, but I will satisfy myself, content myself with just two examples. One is taken from an address given by a Liverpool magistrate a year or so ago about the conditions in Liverpool, where she says, this is an address by Miss White, who's a Justice of the Peace in Liverpool. She says that in Liverpool, this is now much more open and is chiefly due to the use of cars. It's very persistent, particularly in certain areas of the city. Most unlikely women are molested, followed, and sometimes attacked. Victims have included a woman of 80 and women teachers on the staff of one of the schools who have been given friendly protection by neighbouring housewives. And there is a good deal more on the same sort of lines. I've had letters particularly from the Manchester area which shows that it's just as rife and troublesome there as it is in Liverpool. It's very well known to be troublesome, I think, pretty well all over London. And I had a letter from a young woman who lives in the Notting Hill district, out of which I would like to quote a short passage to your lordships. She says, I'm the eldest of a family of 5 daughters living in Notting Hill, which is a notorious area of London, but nevertheless one where many ordinary people live and work. In this area, there is a constant stream of men in cars and on foot who spend their time accosting any female from the age of 12 to 60 at any time of the day and night. During my school days, I used to dread the walk home in spite of my uniform and the books under my arms. This is going on, my lords, all over the country at the present time, and it's really high time that it stopped. I think it is so well known that this is an evil that there's really no need for me to spend longer on stressing it to your lordships. I submit that it's clear enough that this curb crawling is a real nuisance, just indeed as soliciting by women had become a real nuisance in London and other large towns before the Street Offences Act itself was passed. It seems clear to me that under the present law, the police are really quite powerless to deal with this nuisance. Though it's true to say that when questioned in another place, the recent Home Secretary did say that there were early Victorian Acts of Parliament under which it was possible, in certain circumstances, to bring proceedings. This seemed to me to be just stalling, really, and I suggest that if the one nuisance, the nuisance of the women, could be remedied by the Street Offences Act in 1959, so can the other nuisance, which is now very much of the same character, be remedied by another statute, the statute before your lordships this afternoon in 1968. I've told your lordship that I had 2 reasons for proceeding by way of amending the Street Offences Act, and not, as I could have done, by suggesting a new clause to be added to the Sexual Offences Act. My second reason is that the 1959 Act is aimed solely at the common prostitute. Section 1, which is the operative section, relates only to common prostitutes. Prostitution, of course, my lords, is not a crime in this country, and many people feel that it's basically unjust to single out a section of the community for isolated treatment in this way. It's our boast that all citizens are equal before the law. By all means, make it an offence to loiter or solicit in a street or public place for prostitution, but make it apply to both sexes, to all citizens, and not just to a single class of women singled out as common prostitutes. This is the principle on which the present bill proceeds, my lords. I've said that in the 1959 Act, was effective to improve the conditions in the streets in London and the other large towns, to deal with that nuisance, and it undoubtedly was a nuisance, just as curb crawling at the present time is a nuisance. Some may argue that the removal of the term common prostitute from the clause will lead to a revival of the situation as it was in London and other towns before 1959. I see myself no compelling reason to believe that that should be so. I think that the main reason why the 59 Act was effective was because it increased the penalties, and increased them very substantially, especially after successive crimes. I wouldn't contend that the singling out of common prostitutes for punishment didn't have some effect. I think it may have had one side effect, which probably wasn't foreseen, that it frightened off a large number of amateur prostitutes who didn't wish to be singled out and categorized in that way, which they became afraid of when the Act was passed. But if you think about it, there are many reasons why this dealing with the common prostitute in this way was wrong. For one reason, it placed a very great deal of power, and indeed of subject to temptation, the police force themselves. But all this only increases the force of the case for removing the common prostitute as such from the Act. My Lords, before turning to the details of the bill, which I would do in a moment, there is one further observation of a general character which I wish to make, and which I feel raises a question of importance which some of your Lordships at any rate will wish to discuss this afternoon. It has been suggested that this bill could involve an interference with the liberty of the subject. Now, nothing is further from my intentions than to interfere with the liberty of the subject, and I do not believe that a careful scrutiny of this bill will show that anything of the sort is likely to occur. If any valid criticism of this kind can be put forward, I am prepared to promise here and now that it will have the very closest attention, and we shall be very ready to accept amendments at the committee stage to put it into operation. I am myself very sensitive to questions of personal liberty. National Council of Civil Liberties, of which I'm a member and of which I was one of the first members, wrote to me about this subject. I asked them for chapter and verse of their criticisms. It was only within the last 24 hours that I received a reply, and that reply really shows that their main fear is in respect of the clause which gives the power of arrest to the police. And that is my noble friend Lord Arron's main point too, and I would like to say a few words more about it in a moment. But first, let me just speak shortly about the general problem. Of course, every criminal statute involves a problem of liberty. Every single statute in the criminal law. It's the point at which a man or a woman uses his freedom of action so as to seriously interfere with the rights of his fellow citizen that his freedom has to be restrained, and has to be restrained by the criminal law. And it's always really a question of just where you're to draw the line. It seems to me that curb crawling has developed to the stage where it has in fact become a public nuisance, and where the liberty of the curb crawler to upset the peace of mind of respectable women will have to be restrained. I certainly agree that ordinary social invitations of men to women or of women to men met with in the streets, boy meets girl, should not be the concern of the criminal law, even where they may extend to the purpose of sexual intercourse. That's not what we're concerned with. But I submit that this is looked after in the bill by the element of persistence or of molestation which it requires. If it's your Lordship's view that something more explicit is required, we can put that in at the next stage. I shall certainly be most happy to consider all suggestions to that end. And we can put any situation of that kind right when we deal with these matters in detail in committee. I would now like to return just for a moment to the police aspect, which I referred to a moment ago. It's really just a special aspect of the problem with which I've been dealing. It arises, of course, from Clause 1, Subclause 5, which gives the power to the police to arrest without warrant. And this, of course, is Lord Arran's main, indeed I think his only real objection to this bill. And it's for this reason that he proposes to move the amendment which stands in his name, which, as your lordships know, would have the effect of rejecting the bill altogether. I'm very grateful to my noble friend Lord Arran, who, with his usual courtesy, has explained to me his fears and has indeed given me a copy of the speech which he proposes to make to your lordships this afternoon. I have a great deal of sympathy with his views, and I would like to answer them now rather than to make a second speech later on. If they're well grounded, we can deal with them, of course, in committee. But in any case, I do not think that they are so serious as to merit the rejection of this bill. I must explain at once that the clause is an exact replica of the existing one in the 1959 Act. In drafting the bill, my lords, we decided to leave as much of the old Section 1 of the existing statute as seemed applicable, as seemed to be useful, which indeed is the whole of the section except for the first section, because it's only the first subsection, because it's only really the first subsection of the Street Offences Act which will go under the present bill. But we thought that it would be best to have the whole of the little bit of law which deals with this subject in one Act of Parliament, rather than leave it, so to speak, to be straddled by two. This is a criticism which has been heard a great deal of recent years at the number of different Acts of Parliament that you have to look at in order to find what the law is. And in drafting this section of this bill, we were trying to make a little contribution towards dealing with that situation. I'm aware, my lords, that this section of the 1959 Act gave rise to a great deal of uneasiness in both Houses of Parliament. At the time of the passage of that bill through, but after very nearly 10 years of operation, it did not appear to us that these fears had been proved to be well grounded. There's been very little criticism of the behavior of the police in making arrests under the 1959 Act, and obviously the police have got to play a part in this sort of situation, so that on the whole we didn't see that there was any reason for interfering with this particular part of the 1959 Act. There seemed to be no valid reason, therefore, for amending the subsection, and I hope that my noble friend Lord Stonham will possibly be able to throw some light on this part of the situation. My lords, I do not blink the fact that the widening of the scope of the law, which will follow from this bill, it does increase the chances of mistakes being made by the police in connection with arrests, though I hardly think that it is likely to lead to numerous cases of mistake. But I think that in committee we should be able to find methods of reducing these and possibly of eliminating them altogether. There has, my lords, been built up under the present Act a system of cautioning which might well be looked at for the purpose of improving the position when we come into committee on this bill. And the sort of amendments which I mentioned, by which the actual conditions of criminality can perhaps be tightened up, would also make it more unlikely that there would be mistakes made by the police in effecting arrests in this sort of case. I suppose at the end of it all, your lordships may have to choose between the hardship of an occasional mistaken arrest and the very real hardship which this situation is causing to very large numbers of women at the present time. There's always, of course, the possibility of a mistake in arrest being made in the administration of the criminal law. It is not in any sort of way peculiar to this type of bill. We ought, however, not to reach a decision in my submission about this matter at this stage. It's eminently a matter for detailed discussion at the committee stage. And I hope that Lord Arran will, after considering these matters, be prepared not to press his amendment. After all, if at the end of it all he comes to the conclusion that he's still in doubt as to whether what we have done satisfies his needs, he can move for the elimination of this particular clause from the bill or take various of other steps which are open to him for safeguarding the position. I hope, therefore, as I've said, that he will agree not to push his amendment this afternoon. I now turn to the terms of the bill. It's really very simple, and it doesn't require very much explanation. But first I would like to refer to a small error in the explanatory memorandum at E, where it says in section 5 it should read 6. There were originally 5 subsections. Another one was put in, and we failed to notice that the explanatory memorandum would need revision on that basis. I should perhaps tell your lordships that at the time when the bill was in draft, I sent a copy to the Home Office, hoping to receive their comments, but after a fortnight or so, not having heard anything, I assumed that they hadn't got any, and as Christmas was getting near, I decided to take the first reading. Very shortly afterwards, I received a very useful letter from my noble friend Lord Stonham, containing quite a number of comments on the drafting. I don't think he objected to the principle of the bill at any point, but he did make a number of comments on the drafting, and it might be that if I'd had these a little earlier, the bill before your lordships this afternoon would have been rather differently drafted. But all these matters are, in fact, matters which can be put right at the next stage, and I don't think they provide any reason whatever why this bill should not have a second reading. The position of a Member of Parliament, of course, introducing a bill of this kind is a rather difficult one, because legislative drafting is very much an esoteric art. One has to do one's best with the help available. Actually, I've had a great deal of most valuable help from knowledgeable friends to whom I take this opportunity of expressing my gratitude. And I really think that the bill isn't as badly drafted as all that. There are some bills on the statute book which are certainly not very much better. I've never seen a bill introduced by a private member which has not been heavily attacked for its drafting by the minister in charge. I've no doubt with a great deal of justice. When the government can be persuaded that Parliament is determined to see a private member's bill become law, then it tends to put the parliamentary draftsman at the disposal of the member who is putting it forward. And that is my hope in the present case, that your lordships will give me a second reading and that the government will then lend me a draftsman so that we can put the bill into better shape. I understand that the government are not going to oppose the bill, that they're going to take up a neutral position, which indeed is the most, I suppose, that a private member could expect in this sort of situation. With regard to the actual terms of the bill, I need only say a very few words about that. The first subclause is really the operative part of the bill. It widens the present Act by substituting the words other person for the words common prostitute, and substituting the words immoral purposes for the words purposes of prostitution. In both these respects, it of course widens the scope of the present law quite a bit. The types of conduct aimed at are described by the same expressions as those used in the 1959 Act, that is, the word loiter and the word solicit, though we have in fact changed the drafting. We hope for the better, but if the general view is against that, it can always be put back. Subclauses 2 and 3 are really concerned with defining the scope of subclause 1. The first point to notice here, I think, is that the expression soliciting, which is not defined in the present Act at all, and which it could be argued that for the purposes of sexual offences it can only be practiced by a woman, this obviously ought not to be left in that situation, because the main object of this bill is to establish a uniform rule in these matters for both men and women, and therefore subclause 2 makes it clear, I hope beyond a peradventure, that both men and women may be guilty of soliciting for the purposes of the Act. The subclause goes on to make it clear that 2 main types of soliciting, that is, importuning and molestation, are in question, and this, I think, should make it clear that casual invitations in the streets of the kind which I've mentioned, casual invitations not persisted in, are not within the mischief of this bill, and relieve the fears of those who feel strongly about the civil liberties point. Under subclause 3, immoral purposes includes males or female prostitutes, and covers both heterosexual and homosexual conduct. That widens again. And it's made quite clear that the word loiter will in future cover the curb crawler, which is one of the more important objectives of this bill. Clause 4 and 5 come from the present Act. I ought also perhaps just to call attention very shortly to subclause 6, which repeals a number of Victorian statutes which, as operative parts of the criminal law, were in fact repealed by the 1959 Act. But they were kept alive to the extent that convictions under them can be used at the point when it comes to decide what punishment has to be meted out. They can, as I've told your lordships, the punishment goes up in steps under the 59 Act. These convictions under these early Victorian Acts could be used, so to speak, for making the steps. My lords, very nearly 10 years after the Street Offences Act was passed, it seems to me, and to those who think with me, that really these Victorian statutes might very well be discarded altogether, and we therefore decided to repeal these statutes again without any qualification of the kind which occurred in the 1959 Act. My lords, I do not think that the terms of the bill require any further explanation. I beg leave to move that the bill be read a second time.
The question is that this bill be now read a second time.
My lords, the bill which my noble friend Lord Chorley has just introduced raises very difficult and controversial issues. And whatever our views on them, we can, however, be grateful to him for putting them before us this afternoon, and for giving us an opportunity for what I'm sure will be an interesting discussion. Lords, may I first say something about the government's attitude to this debate. Any proposed change in the law on this subject clearly calls for the most searching examination of both the principles which underlie it and the repercussions which it might have on public order and on a grave social problem. And it would be my duty to draw attention to some of the serious issues that underline the bill and to the practical and technical difficulties about it. But it seems to the government right that your lordships should be free, having heard the debate, to vote on the issues of principle and to decide whether the bill should have a second reading. I shall not, therefore, seek to advise you either to oppose or to support the motion before us. But clearly, the government will have to keep its attitude to the bill under review in the light of the debate today and any further progress the bill may make. My Lords, my own personal views on the Sexual Offences Act 1959 are very well known and they have not changed.
Street offences.
The street offences, I'm so grateful to know if I can, on the street offences, equally true of the other. They've not changed. Many of your lordships know that I was among those who strongly opposed the 1959 Act when it was debated. I thought then, and I think now, that an offence of soliciting, which applies only to a person who, when charged, is charged as a common prostitute, that it makes it impossible not to import prejudice into the decision whether the woman concerned is guilty or not guilty. Nevertheless, it's one thing to have doubts about particular provisions, and it's quite another to see how the law could be changed without causing further and perhaps greater difficulties. And I would remind your lordships that what we have to discuss today is not only a question of principle, but the particular provisions of the bill now before us. My noble friend, Lord Chorley, very properly said, if there are parts of it that you don't like, well, I should be very pleased either to alter it or even to delete a whole section. But, my lords, I have to deal with the bill which is now before us, and it's my duty to draw attention to some of the practical issues that arise. And I feel bound to say that, although, as I've already made clear, I sympathise with a very great deal that my noble friend had to say, I cannot consider the drafting of his bill is satisfactory. Now, it seeks to amend Section 1 of the 1959 Act, which implemented the recommendations on prostitution of the Wolfenden Committee. It was designed to remove a public nuisance from public gaze. There were those, including myself, who doubted whether it would achieve this object. But we must now agree, and indeed my noble friend Lord Chorley agrees, that those misgivings were unjustified. The Act has largely succeeded in its purpose. In 1958, the last full year before it came into force, there were 19,663 prosecutions against prostitutes. In 1966, the last full year for which I have figures, the number was 2,137. We've confirmed with the police a fact which, from our own observations, most of us are aware, that there's been a very considerable drop in street activities by prostitutes since the Act came into force. One has only to walk around certain areas of the West End to know that the position is now vastly different, at least in this respect, from what it was before the 1959 Act came into force. Another fear that we had was that if the 1959 Act succeeded in clearing the streets, it would do so at the cost of creating more serious problems by driving prostitution underground and, as it were, sweeping the dirt under the carpet. This fear has been justified to the extent that one of the results has been a change in the methods used by prostitutes to contact customers. For example, the call girls, the proliferation of their cards in certain shops, and the thinly disguised advertisements of various kinds. My lords, no one of us seriously imagines that the oldest profession will ever be stamped out in any country. But many of these changes were largely predicted by the Wolfenden Committee, who carefully considered the risks and concluded that, in general, they were less injurious than the presence of prostitutes in the streets. We've been keeping the situation under review, and certainly we have no evidence leading to the view that there's been any large-scale underground organisation of prostitutes, or that the 1959 Act has led in general to any new and serious problems such as to outweigh its advantages. There are other aspects of the way in which the Act has worked. It introduced a procedure whereby a woman must be cautioned at least twice before being prosecuted. This procedure is still followed. It has two objects. First, to give an opportunity for the woman cautioned to be put in touch with a probation officer or other social worker in the hope that she might be diverted from her life of prostitution. Secondly, as a safeguard for the respectable woman who might otherwise be arrested and prosecuted by mistake. It must be admitted that the procedure has not been as successful in its first object as we had hoped. Nevertheless, a woman does occasionally ask to be put in touch with a welfare worker, and we don't dismiss this as of no value. We've no categorical evidence that the procedure has succeeded in preventing absolutely the prosecution of respectable women, but the police tell us that the number of women who apply for cautions to be expunged is negligible, which does suggest that cautions are only administered in appropriate cases. Nevertheless, we think that the procedure must have some value for its second purpose, because it gives additional protection against any possibility of prosecuting a respectable woman. Lords, I must also refer to the prostitutes who are sent to prison, because I know that this causes concern to others besides myself, not only the fact of imprisonment, but also because short sentences have very little value for rehabilitation. Under the provisions of the 1959 Act, and I would emphasise that these provisions would be unchanged by the bill we're now considering, a prostitute cannot be sentenced to a term of imprisonment unless she's been convicted of a similar offence on at least 2 occasions. The maximum sentence is 3 months. Of the 2,137 prosecutions for this offence in 1966, 46 charges were withdrawn or dismissed. The majority were dealt with by way of a fine, but 269 resulted in sentences of imprisonment, of which 214 cases carried sentences up to 3 months. Lords, of course, only speaking of those where there was an actual sentence of imprisonment and not in cases where there was a fine and somebody went to prison by default. Lords, what happens to these women when they go to prison? Usually, for a variety of quite good reasons, to Holloway Prison. I don't believe that we can do much rehabilitative work with any people who are subject to short sentences. But prostitutes in prison usually improve in health, and we do whatever we can to reclaim them in other ways. True, my lords, we get more good resolutions and positive permanent results, but we are able to do useful work in some of these cases. And I think, my lord, that describes as accurately as I possibly can the position after nearly 9 years of the Street Offences Act. What we've now got to consider in the bill now before us is whether we can countenance any change that might make it more difficult to enforce the law against street soliciting by prostitutes. And I feel bound to say that we think my noble friend's proposal would be more difficult to enforce than the present law, and that the possible consequence would be the presence of more prostitutes on the streets. And there are no doubt many people who would be dismayed if that were to come about. Now to turn to 2 other issues raised in the bill. First, the offence created by Clause 1 of the bill would apply equally to men and women. Now, I hope that the great majority of people, like myself, support equality in these matters between the sexes. But the question to which my noble friend's bill gives rise is how widely we want the law to bite. As his bill stands, he would make it an offence for anybody to loiter for immoral purposes. Again, my noble friend said it's not his intention to interfere with the liberty of the subject. But I shall be mentioning later our doubts about how immoral purposes might be interpreted. But leaving aside the very real danger that perfectly innocent West End loiterers might be in danger of arrest, the question I now ask is whether it's intended, as the words of the bill imply, that a criminal offence should be committed by, say, any youth or girl or man or woman who loiters in the street and intentionally or otherwise makes a casual pickup with the result that it might lead to intercourse. My lords, fornication is immoral, it's a sin. But this bill makes it a crime to seek it. And on the words now before us, it could vastly enlarge the number of people who might be in danger of imprisonment. My lords, is the mere fact of loitering for an immoral purpose, however we define it, to be sufficient to attract the weight of the criminal law? Or is the proper concern of the criminal law, as at present, conduct which can be shown to have created such a social nuisance that the law must intervene? Another aspect of the proposal to apply the offence equally to men and women is that it equates soliciting for homosexual purposes with soliciting for heterosexual purposes. As the law stands, and this my noble friend dealt with, it's an offence under Section 32 of the 1956 Act for a man persistently to solicit or importune in a public place for immoral purposes. And this carries a maximum penalty of 2 years' imprisonment. But the maximum penalty for women under Section 1 of the 59 Act is 3 months. How should equality work? And my noble friend's bill doesn't seek to repeal Section 32, although it's obviously intended to cover the same conduct. I thought I heard my noble friend say that no, it's not. But
I make the remarks standing up as I ought to have done. No, I think that Crook and Edmondson makes it quite clear that it's not, and it's a completely different type of offence. What we want to do is to bring this sort of conduct into the same category of the summary offence and not treat it in something in the nature of an indictable offence, which it is under the Sexual Offences Act. I don't think the Sexual Offences section is useful for the purpose for which it was originally drafted and for that type of offence, and it's used a good deal in connection with making provision for homosexual and sexual conduct.
Well, I didn't convince my noble friend the first time I discussed this issue with him, so obviously I'm not going to convince him now. I can only put the point on the interpretation that I'm advised is the correct interpretation of the words in his bill. But if I am right, then there is a risk that it would weaken the law against the proselytizing activities of homosexuals. This, of course, isn't an easy matter to decide, and together with the whole question of the relative penalties, it's something that your lordships may feel ought to be considered far more fully than is possible in the context of this bill. Lords, there's one aspect of my noble friend's bill on which I feel sure that virtually the whole House will agree, and that is that through the application of Clause 1, as well as to men as well as to women, and by the definition of loiter in paragraph 3 of the substituted Section 1, that's my noble friend's Section 1, he sets out to deal with the curb crawler. My noble friend had a good deal to say about this and quoted examples I'm quite sure that there's no exaggeration about it. In some cities in this country, it is a serious menace, and no one can have any sympathy for the man who indulges in this rotten practice. They are a serious nuisance, and they're a menace to respectable women. And until recently, in my department, we had thought that Section 32 of the Sexual Offences Act could be used to deal with this kind of conduct. But as my noble friend has made clear by the Cook versus Edmondson judgment of 1966, we find that this is no longer the case. And I agree with him that this is a serious deficiency in the present law, and there is a great deal to be said, everything to be said, in fact, for a clear provision to put it right. But, my lords, and I think this is important, I'm sorry to say we are uncertain whether my noble friend's bill, as drafted, would put it right. And here, although I don't like troubling your lordships with what are primary committee points, I'm bound to say that it contains a number of obscurities which in fact make it difficult to say what interpretation should be placed on it, and which would in all probability make it therefore difficult to enforce. And I do think, in a bill of this kind, there must be certainty, absolute clarity of language, and no dubiety at all about intention. For example, if we turn to the new section which the bill proposes to substitute for Section 1 of the 59 Act, and if, my Lord, you look at subsection 1 of the new section, you'll see that it ends with the words, and I quote, either to loiter for immoral purposes or to solicit. It doesn't say solicit for immoral purposes. The word solicit is not governed by the words immoral purposes. Although in subsection 2, the word solicit is defined as to include any form of persistent importuning for immoral purposes and molestation for immoral purposes by offensive words or behaviour. It's not clear in the context of the bill whether this is an exhaustive definition, but if so, and it was necessary to show persistence or molestation in every case, the offence then would be difficult, if not impossible, to prove. And with a narrowed offence of soliciting, the offence of loitering for immoral purposes might not on its own be sufficient to prevent the return of prostitutes to the street. The essence of the offence under Section 1 of the Street Offences Act is loitering or soliciting in a public place for the purpose of prostitution. The element of persistence or molestation is not required, and it's this which has given the 1959 Act its substantial deterrent effect. Now, my lords, my noble friend referred to the fact that in his bill, quite rightly, he has repeated some of the sections of the 1959 bill. He referred in particular to his subsection 5, which reads, a constable may arrest without warrant anyone he finds in a street or public place and suspects, with reasonable cause, to be committing an offence under this section. That is exactly the same as subsection 3 in the 59 Act. But suspects under this section of what? Under the 1959 Act, he suspects the person concerned of committing the offence for a common prostitute to loiter or solicit in a street or public place for the purpose of prostitution. In this bill, the person will be committing the offence of loitering for immoral purposes or to solicit. That's a vastly different thing. And we really must bear these things in mind when we are considering a bill of this importance. Then again, in seeking to deal with a curb crawler, and here I'm 100% with my noble friend in wanting to deal with the curb crawler, my noble friend would make it an offence to loiter in a vehicle for immoral purposes. And he defines immoral purposes as including male or female prostitution, whether heterosexual or homosexual. In the Cook versus Edmondson case, as my noble friend has made clear, the court held that the words immoral purposes have a restricted meaning, and they don't cover soliciting by a man or woman for the purpose of having sexual intercourse with her. I can't say, my lords, how the courts would interpret my noble friend's words immoral purposes in this bill, but it may be that the courts would again give the words a restricted meaning, which means that my noble friend is relying on the definition to catch curb crawlers in subsection 3. That is, the definition that immoral purposes includes male or female prostitution, whether heterosexual or homosexual. If he does, then I must say that we doubt whether it does so. It's fairly arguable, my lords, this is a point I want to put to my noble friend. It's fairly arguable that the purpose of prostitution would be interpreted as meaning for the purposes of plying that trade, and that this would not apply to the curb crawler who's not in the trade. He's just as ready to accost a respectable woman as a prostitute. It may be, my lords, that our doubts on this point are not well-founded, but they're certainly sufficiently strong to indicate that the bill is not clear enough on it, and surely if we are setting out to reverse the decision in Crook versus Edmondson, the words must be such as to make the issue clear beyond doubt. My lords, my noble friend has referred to my right honourable friend's predecessor in another place, and the statement that he made on the 27th of July, when he said that he was proposing to ask the Criminal Law Revision Committee to review the law on sexual offences, and that's all sexual offences, including, in the light of Crook versus Edmondson, the law on soliciting by men for immoral purposes. Now, it's hoped, in reply to my noble friend's question, that this review will begin this year, and therefore the House can be assured that the problems with which the bill is concerned will be examined very shortly by the Criminal Law Revision Committee with its accustomed thoroughness and care. And I hope the House will share the government's view that it's preferable for soliciting by men to look at in that way in the context of a review of sexual offences as a whole. Lords, I've tried to set before you some of the practical doubts and difficulties that arise from a consideration of this bill. Questions, I submit, which must be settled if the bill is to be made viable. I've indicated that in our view it contains obscurities which make it difficult to say how far it fulfills its intentions or what its effect would be. And again, I'd remind you that the whole question of curb crawling is shortly to be considered by the Criminal Law Revision Committee, together with other aspects of the law. I mention this again simply to give you as full a picture as possible of the issues surrounding the bill, and in the hope that it will assist you in coming to a decision. My Lords, that decision is entirely for you.
My Lords, I beg to move as an amendment to the motion for the second reading to leave out the words now and to insert this day 6 months. My Lords, in doing this, I must make it clear that I speak as an independent peer and in no sense as representing the benches on which I sit. Indeed, I suspect that they do not altogether sympathise with my point of view. Lord, I'm sorry and unwilling to oppose this motion. The noble Lord, Lord Chorley, strongly supported the recent Sexual Offences Bill, and in words which I still regard as some of the bravest spoken during our many debates on that subject. I have a deep respect for it. I have also a deep respect for his bill. Its purposes are excellent. And I go along with several of them. But I must say that I believe it to be far too widely broad. And indeed, that one of its major clauses, at least, is a danger to our civil liberties. But first, my Lords, let me briefly explore the area in which I find myself in agreement with him. First of all, I agree entirely that in the matter of soliciting and importuning, men and women should be treated pari passu, as is the case in almost everything these days. Your Lordships will recall that when the Street Offences Act of 1959, on which I made my maiden speech incidentally, was debated, this point was one which deeply occupied the House's attention. There was a strong feeling that the client, as well as the prostitute herself, should be charged. And the word common prostitute came in for almost universal reprobation. Indeed, I cordially dislike it too. The phrase is in itself an a priori condemnation. But, my lords, to substitute the word any person, although superficially attractive, is a very different matter. It brings with it new dangers, which I will go into later. Moreover,